You're listening to the Law Biz News podcast with Glenn Duker. Law Biz News is for business owners and property owners and is designed to answer real-world questions in a very practical way. My name is Glenn Duker and I'm a lawyer at PCL Lawyers in Melbourne, Australia. Today we're going to discuss three types of tenant issues. Firstly, the 5-year minimum term available to a tenant in Victoria, key money, and thirdly, we're going to look at VCAT, which is the Victorian Civil and Administrative Tribunal, as an enforcement measure for a tenant. It doesn't matter what jurisdiction you're operating in Australia, there are more protections available for retail tenants than ever before. Most of these protections are embodied in state legislation, and in Victoria, that's the Retail Leases Act 2003. The introduction of this baseline legislative protection for a tenant has really paved the way to make things easier and largely prevents landlords from taking advantage of the unsuspecting tenant. Firstly, we need to ask the question, who is a retail tenant? What's the difference between a retail tenant and another type of tenant? Well, a retail tenant, in essence, is a tenant who operates a retail business from their premises, or that this retail purpose is the predominant purpose associated with the trade from the premises. Many think that this only includes shops in retail shopping centres or in strip shopping centres in the local area, but it actually encompasses many more businesses than one might expect. If the public has the ability to walk into your business and trade with you, in theory, you're a retail business, subject to certain exceptions. And importantly, even if the lease purports to state that the lease is a non-retail lease, if the purpose is in fact a retail lease as defined in the Retail Leases Act, it will still be a retail lease. So in other words, the legislation, the Act, overrides any special conditions or any other conditions in the lease. Now, the Retail Leases Act offers a retail tenant a minimum 5-year term. Now, that will mean that from the start of the lease until the end of the lease, inclusive of all options, a new tenant will be allowed 5 years in the premises. So, in practical terms, this might mean that the new tenant initially has a 2-year term. It will be assumed that another 3 years by way of option will be available. So this gives a tenant sufficient time to establish their business and not be worried about being thrown out of the premises by a landlord. This also has a serious impact on landlords, and landlords need to consider their circumstances when offering a tenant a lease of the premises. Now, there are exceptions to this rule, such as when the lease being entered into is in fact a sublease, and there is a head lease which has less than 5 years to run. But most tenants can look forward to at least 5 years tenure, provided the tenant doesn't persistently default under the lease. Now, another protection under the Retail Leases Act for tenants is that landlords cannot charge a tenant key money. This means in practice that there is no flagfall type fee available to the landlord when a tenant enters the premises. In other words, there can be no upfront fee charged for the right just to lease the premises. A breach of this provision entitles a tenant to terminate the lease. Furthermore, sometimes landlords will try to include other onerous clauses such as trying to prevent the rent ever being decreased in a market review situation. These are also known as ratchet clauses. Any such clause in a lease is void, and the law as set out in the Act will always prevail in this case. In the unfortunate event that you do have a dispute with your landlord and no agreement can be reached between both of you, the matter will need to be referred initially to the Small Business Commissioner, who will arrange a compulsory mediation date for you. And this allows the parties to attend the Small Business Commissioner's office and sit down with a mediator with a view to trying to settle the matter. Many matters in fact settle at this stage, and the very fact that the parties are in a room together, whether legally represented or not, brings about an opportunity for a meeting of minds and a settling of disputes. If the matter can't settle by mediation at the Small Business Commissioner, a certificate will be issued which will entitle either party to commence proceedings at VCAT. The exception to this, of course, is in urgent situations when injunctions might be required to prevent certain action by a landlord pending the further determination of the issues, but generally this is the path that retail lease disputes take. So, if someone issues at VCAT, what happens? Well, the advantage of VCAT is that it is a relatively inexpensive jurisdiction to commence proceedings, much less so than a court. Further, the rules of evidence are somewhat relaxed. Nevertheless, applications still need to be brought, cases effectively need to be pleaded, although this is done in the form of points of claim rather than a statement of claim. VCAT is championed by many as a cheaper, faster and easier forum to litigate in. In many cases it is. Perhaps a downside in the retail leases list at VCAT is that costs are not available as a general rule. Part of the philosophy behind this is that it is supposed to encourage parties to settle quickly, and often this is the case, it does work. The downside, however, can be when a party has complex legal arguments, they need to engage lawyers anyway to make submissions on their behalf. Now, it costs money, obviously, to hire lawyers to represent a party at VCAT. But if there's enough money at stake, there's just no other option. What this means, however, is that smaller cases with sound legal arguments are often not heard. But that's the way it goes. It's the price of having an efficient system in place, which avoids the need and the expense and the complexity of the normal court system. I like VCAT personally, and I think it functions very well. I think that the members are very interactive, and they do have a genuine desire to see matters resolve, which at the end of the day is usually better for the parties anyway. If you do have a retail leasing dispute in Victoria, you must initially take it to VCAT. The courts are not an appropriate forum for a retail lease dispute, at least not initially. The best approach if you have a dispute about your lease, or even a question about your lease, is to get legal advice about your individual circumstances quickly, so that you can be sure about your particular legal rights in relation to your lease. Thank you for listening today. My name is Glenn Duker. Bye for now.